Welcome. You're listening to The Best of Investing. I'm your host, Edward Brown, and my two co-hosts, Mark Hanf and Nam Phan, are off today, so it's just mono. Hold on a minute. We're going to have a guest on in just a second here. Our phone number is 888-912-1190. You're going to use that number to answer the trivia questions for a 5-pack tanning certificate given away during this show, and that certificate's not sponsored by the radio station, but by Tan Bella Tanning Salon with 2 locations in San Francisco and 1 in Marin. Today's trivia theme is general trivia. Now, we do have a special guest, real estate lawyer and mediator, Phil Diamond, who has been a friend of the show for many years. He's been on it at least 2 times before. And in addition, Phil has been an arbitrator and practiced for over 45 years, a graduate of UC Berkeley's School of Law. And the best part, Phil is also a real estate broker and investor. I like that part. Phil, welcome to The Best of Investing.
Thank you very much, Edward. It's good to be back. I was looking at your website the other day and realized we are about our 10-year anniversary since the last time we were together on the show.
Are you serious?
Could not believe it. No, but
wow.
That's true.
Wow. Okay. Well, we can't wait every 10 years to have you on, because I know things do change quite a bit.
They do. They do.
So, in addition to being a real estate broker and investor, specifically what we wanted to talk about today, and we'll talk about other things too, but your real specialty seems to be mediation. Is that correct?
Yes.
Okay. And
yes.
Is it primarily in the real estate field?
Edward, no, I mediate in all areas of civil disputes other than divorce. Divorce is a specialty area that I defer to others, but other than that, no, I mediate any civil dispute. Many of those involve real estate matters, but they also involve things like employment claims, bodily injury claims, investor fraud claims. Pretty much anything that could be resolved in the court of law is something that I handle as a mediator.
And if you were to handle a divorce, you'd have to probably go in with a suit of armor, because I know how contentious. I mean, I've never been divorced, but I understand those can be quite contentious. So
they can, and actually, I do get into similar situations. A number of the disputes that I handle involve trust and probate disputes among family members, and as you can imagine, those oftentimes are as emotionally charged as a divorce, and sometimes even more so.
Yeah, in fact, we're going to be doing a loan for one of the siblings who wants to live in the house that she grew up in, but the other 2 siblings, the brothers, are saying, "Hey, we want our part of the estate, so cash us out." And there aren't too many banks that'll do that, so we're going to be able to provide them a loan. So at least, from your standpoint, getting into the mediation of the arguing between them, at least we can kind of come to a solution to make everybody happy on that.
Good.
And I got to tell the audience, I've known you now for at least 10 years. And I got to say, I've met a number of mediators, but I really appreciate your demeanor. Because it's true. You're a problem solver. You don't jump on one side or the other. You try to have a very even keeled approach. And that's definitely what I would want in looking for someone who does mediation. So let's, before we get to our first break, I do want to get into just really quickly, what is mediation?
Sure. Think of it as a structured negotiation where the parties jointly hire a third person, the mediator, as a neutral facilitator to help them to resolve whatever the dispute happens to be. Again, it is a structured negotiation in which the mediator helps the parties to craft a resolution of their own with the mediator's help. And upon conclusion of the mediation, it results then in a settlement agreement or a term sheet, some document that sets forth all of the terms that have been agreed to and is signed by the parties. If the matter is in litigation, that then becomes a binding and enforceable agreement that the court can enforce. If the matter is not yet in litigation, and I mediate a number of disputes that are not yet in litigation, then the court has not yet entered into the process, so the court isn't in a position to enforce it, but that settlement agreement then becomes a contract that is enforceable by either party.
Gotcha. So if I understand it correctly, if it's not been litigated yet and you're just doing the mediation, even if both sides agree, in theory, one could break that contract. And in that case, the other party would most likely sue in court to enforce that contract, which I would think would be pretty strong. Because it's not just some old contract done by a couple of people. I mean, your mediation. I mean, you're really kind of cutting down to the real meat and potatoes. How often does that happen, where someone has a change of heart after?
It's very rare, Edward. Usually, when it happens, and I've seen it happen maybe only a few times over the 17, 18 years that I've been doing this. Usually it involves one or two specific terms among a number of terms that have been agreed to.
Okay.
And usually those terms then can be resolved simply by further mediation efforts to get it across the finish line.
Gotcha. Okay, hey, we're going to cut to our first commercial break here. General trivia is our theme. And again, Phil, if you remember from years ago, if you know the answer, don't say anything yet. We'll let you answer when we come back from break. We don't want to spoil it for the audience. So here's our first trivia question. What is the name of the avenue that lies between 12th and 14th Avenue in San Francisco? All right. First caller with the correct answer is going to win that tanning certificate, which is worth over $100. Our phone number is 888-912-1190. Be the first caller with the correct answer. You're going to win that tanning certificate. Stay with us. The Best of Investing. I'll be right back. Welcome back to the Best of Investing. Again, I'm Edward Brown, your host, and my co-hosts are out today, but our special guest, Phil Diamond, who is a mediator, is going to join us in just a second. We're going to first answer the trivia question. Let's see if Phil knows the answer to this one. What is the name of the avenue that lies between 12th and 14th Avenue in San Francisco?
I'm probably totally wrong. I'm going to say Anza.
No, it's Funston.
Funston, there you go.
Funston, yeah. I mean, obviously, people would think 13th Avenue, and they go, nah, 13th's a bad number, bad luck number. So we want to make a quick mention here for if you're looking for a romantic getaway near Yosemite, the McCaffrey House Bed and Breakfast is just the place. It's an enchanting mountain lodge nestled in the quiet forest hollow of the High Sierra in Twain Harte. Included in your stay is a full hot breakfast as well as the happy hour each evening where wine is served. To make a reservation, go to mccaffreyhouse.com, and that's spelled MCCAFFREY house.com. All right, we are in, I say in the studio, it's a Zoom studio, with Phil Diamond, who is an attorney, and we're talking about mediation. And so how does mediation differ from arbitration?
Sure, and that's a question that many people ask. Those who have not been through the process before often mix up those terms. They're very different. I've described mediation already, a voluntary process where the outcome is controlled by the parties with the mediator's help. Contrast that with an arbitration where the arbitrator is actually given the power to order the parties to do something and to enter what's called an award, which is essentially the same as a judgment that would be entered by a judge if the matter were in a court. An arbitrator is empowered to take evidence, testimony under oath, documentary evidence, and to basically weigh that evidence the same way as a judge would in a judge trial without a jury, and then to actually enter an outcome.
And that sounds like binding arbitration. Isn't there non-binding arbitration also?
Well, there is. That's a process that was used by the courts in San Francisco for many years. I used to do it many years ago. I'm actually not sure whether they even do it anymore, but it resulted in a finding by the arbitrator that one side or the other could reject. And if they did reject it, then there were certain sanctions that would flow from that if they didn't do better in the litigation and the trial that followed.
I mean,
arbitration.
Yeah, I was going to say, the thing I like about the binding arbitration, because I got to assume that one gets a qualified arbitrator. You know, it's not just some box boy at Safeway. No offense to the box boys at Safeway,
sure.
Who has knowledge in a certain area, like let's say construction defects or something like that. And the courts get so clogged this is a great way to unclog the courts. And if I understand it correctly, it should be a lot less expensive for the litigants to use binding arbitration, but effectively it's, and things can be a lot more free flowing, can't they? Rather than, strict rules of, it being in a courtroom with, well, go ahead and explain.
Yeah, so let's look at that in a couple of different ways. Mediation, and an advantage of mediation, and one that I mentioned earlier, is that the parties control the outcome. In the arbitration, the parties don't control the outcome.
Okay.
The arbitrator does. And in terms of it being more free-flowing than in court, that is right in the sense that an arbitrator is not bound to follow the same formal rules of evidence as though you were actually in the courtroom. But that said, in arbitration, the parties usually are entitled to the same types of discovery, the pre-hearing discovery, as you would in an actual court proceeding. And depending upon the size and the complexity of the case, that discovery can take quite a long time and can be almost as expensive as it would be if you were actually in a litigation. Now, what's interesting is that in the mediation process, where the parties have control, there has been what I'll refer to as a hybrid that has developed. And actually, this is since the last time you and I spoke on this subject. And that's what's known as binding mediation. So what does that mean? That means that the parties have hired a mediator to help them facilitate a resolution, but they've agreed that if they are unable to reach an agreement, even with the mediator's help, the parties turn the matter over to the mediator to make a decision.
So then in that case, he kind of becomes an arbitrator.
Yes, except that the mediator isn't taking sworn evidence from the parties. It's a more informal process. The mediator is not hearing evidence. He's hearing arguments. He's hearing the things that the parties present, but in a much less formal way.
I like that because effectively it's like, look, guys, let's all sort of play nice in the sandbox with trying to mediate this thing. But if we can't really come to an agreement, we're going to just let it be up to the mediator, which is kind of like going to a judge anyway, where you think you have a case and the other side has a case and you let it be the judge's decision.
Exactly.
Like
and what and the development since the last time you and I were together is that the courts have held that the decision by the mediator under those circumstances then is enforceable by the court, just as a settlement agreement would be enforceable, because essentially that's part of what the parties have agreed to by way of settlement. The settlement is they put it over to the mediator.
And the parties, they have to agree to this binding mediation.
Exactly, and they've got to do that. They've got to do that in writing as well.
Okay, and then how do they pick the mediator? Because each one, might have a friend, or they both have to agree. I assume they both have to agree on the mediator. Yeah,
great question, Edward. The starting point is they do have to agree on who the mediator is going to be, but there are some situations where, for whatever reason, they can't agree. As you mentioned a moment ago, sometimes they'll have their own colleagues or people they've had experience with that they'd like to use. So under the right circumstances, the court actually can decide for the parties who the mediator is going to be.
Sort of like when you go for a loan and the bank chooses the appraiser for you.
Exactly. Yeah. And sometimes what will happen is that the parties will submit a list of 2 or 3 or 4 mediators that they want, and the court then looks at all of them, and through a process where they have the ability to strike 1 or 2, ultimately the court weighs in on it.
All right. When we come back, I do want to talk about, you've got a bunch of great questions for me to ask you here, but I also want to talk about the costs involved, mediation, arbitration, and going to court. Because I'm pretty sure most people know, but I'd like to see the contrasting numbers, because that really can make quite a difference. All right, here's our second trivia question. General trivia is the theme. What title role was filled by Lon Chaney in 1923 Charles Lawton in 1939 and Anthony Hopkins in 1982. The same, basically, what title role? The same movie title role there. All right, call 888-912-1190. First caller with the correct answer is going to win that tanning certificate, which is worth over $100. And don't touch that dial. We are going to be right back. Welcome back to the Best of Investing. Edward Brown here, along with my special guest, Phil Diamond, Esquire, attorney who is specializing in mediation. That's specifically what we're talking about today. But before we get back to Phil, do want to ask the question here. What title role was filled by Lon Chaney in 1923, Charles Lawton in 1939, and Anthony Hopkins in 1982? And Phil?
Well, I'm on a roll here. I'm 0 for 1. Let's see if I can make it 0 for 2. I'm going to say the Hunchback of Notre Dame.
Ding, ding, ding! That is correct. Now, I know you weren't old enough to see the original Lon Chaney or Charles Lawton. In fact, that's the only one I know Charles Lawton was ever in. Was Hunchback of Notre Dame. Okay. So before we cut to break, I did mention on air that I did want to ask you ahead of time, or ask you in this next segment, what are the various costs to having a mediator, an arbitrator, and if you have to go to court?
Sure. So you put those in the order of their general expense. I can't give you specific dollars, but I can give you a general order of which is the most and which is the least expensive. Without question, the litigation process is the most expensive. As you might imagine.
Sure.
It's the longest. It can take a year or two to get from the beginning to the end, and even longer than that if the matter goes up on appeal. It involves lots of what's called pretrial discovery, written interrogatories, requests for admission, requests for production of documents, depositions under oath. All the things that take up the time before the case ever actually gets to the trial. Then you've got the trial itself, and then sometimes you've got an appeal, and sometimes that results in the decision being reversed on appeal, only to have to come back and be tried all over again. So without question, litigation can be extremely expensive, and of the three, it is the most. Arbitration would be the next most expensive. Usually because it can be done faster than a formal litigation, usually. The parties have a bit more control over the timing and the scheduling by working with an arbitrator directly than they would if they were working with a court. As I mentioned earlier, discovery can still be involved that can build up the expenses there. The arbitrator doesn't work for free. The arbitrator is paid by the parties. As well. And by the way, I am an arbitrator as well as a mediator. So these are issues that are near and dear to my heart. And again, the arbitrator is taking formal testimony and evidence under oath, just as if he or she were acting as a judge. Mediation is the third most expensive. It's to put it another way, it is the cheapest and quickest way of resolving disputes. And that's one of its major advantages. Again, the parties pay for the mediator's fees. Usually they split them evenly. Another major advantage of the mediation process, and I'm getting a little bit away from the question you asked, but while I'm on the subject, is it is a collaborative process in that the parties work together with the mediator to figure out a result that works for them, and in many ways can be more creative than the court could ever give the parties if it went to a court. How do we do that? We do that by getting to the positions and the interests of the parties. And what I mean by that, the position of the party is, what is it? What do you want? The interest is why do you want it? Yeah,
I can imagine something like, suing for specific performance. Someone says, I want this house, and and I want X amount of dollars, and, this delay cost me X and Y, and that sort of thing.
Exactly, Edward. And one of the examples that I sometimes give is of the little brother and the little sister fighting over an orange, and each one wants it. So the mom is watching this go on and says, no, stop fighting. Here, give the orange to me and I'll decide it for you. And what do you suppose the mom did?
Cut it in half.
Of course, exactly. That's what most people will say. Every once in a while, somebody says the mom ate it. And that's what we call, in mediation circles, that's what we call a lose-lose. But no, the mom cut it in half is what most people say. But if the mom had known the little girl wanted the orange to have the skin in order to make an orange zest for an orange cake, the little boy wanted the inside to make orange juice, what would have happened? Obviously, the little girl would have gotten the outside, the little boy the inside. That's what we call a win-win.
That's a good example.
And it's a silly little story, but it makes the point.
Yeah. So
that's the purpose of mediation.
I'm not sure if I had, probably since it's been 10 years, I haven't told you this story. So I had a situation where I had to foreclose on a piece of property out of state. And the thing that was very interesting was there was a very, very expensive piece of equipment in the house. And the borrower who defaulted wanted to claim that it was personal property and take it with him, so it was not part of the foreclosure. And my position was, no, it's affixed to the house.
Sure.
It's real property because it was very, very valuable. And there was a potential buyer of that piece of equipment. And so what I did was I got a call actually a letter from his attorney saying, hey, we're going to pick it up, blah, blah, blah. And I called the attorney and said, hey, let me talk to the borrower if you don't mind me. Oh yeah, sure. Go ahead if you can work something out. Right. So I called him up and I said, Mr. Jones, let's see what we can agree on. We can agree on that if we don't sell this piece of equipment to this buyer, nobody's going to make any money. And I said, this is out of state for both of us. I said, what's going to end up happening is you're going to hire an expert out of state, who's going to say that it's personal property. And I'll even give you I'll give you the ammunition for that, the reasoning. But I said, you can also see my part about how it's real property. And I said, what's going to end up happening? We're going to spend tens of thousands of dollars. And in the end, a judge may just kind of go, you know what? They both have an excellent point. Why don't they just split it? So I said, that's what we're going to do. And I seriously said, you've got 10 seconds to decide. How about we just split this? And about 5 seconds later, he said, okay. And
Brilliant.
There was the end of it,
Brilliant. So what you did was you self-mediated.
Exactly. Yeah. And I realized it was going to be, it was going to cost me the potential of, but I realized, I said, you know what, this one's kind of an easy one. Hey.
Well, and the point that you make there, Edward, in all seriousness, is that part of the mediator's role is to make sure that both sides have all of the information they need, or at least as much of it that they need, to make an informed business decision as to what can be accomplished now through resolution, as opposed to the uncertainty and the time, effort, and expense of going forward to have somebody else resolve it.
Exactly. All right, here's our third trivia question. Billy Joel's Uptown Girl music video featured which supermodel? You got to go back to the 80s for this one. Call 888-912-1190. First caller with correct answer is going to win that Tanny certificate. Don't touch that dial. The Best of Investing. I'll be right back. Welcome back to the Best of Investing. I'm Edward Brown, along with our special guest, Phil Diamond. So, Phil, you think you know the answer to this question. Billy Joel's Uptown Girl music video featured which supermodel?
Got to be Christy Brinkley.
It is Christy Brinkley. I tell you, you were 2 for 3.
2 for 3, not bad, right?
That's a batting average of 667. That'll get you to the Hall of Fame. All right. So let me ask you, how has mediation process been affected by the pandemic?
Sure. The most obvious way is that pre-COVID, we used to mediate in person. We'd be together in a conference room for what's called a joint session with all the parties there. And we don't always have a joint session, but oftentimes we do. And at a minimum, we'd have separate breakout rooms where there would be separate spaces, private spaces for me to hold separate, what's called caucuses with each side separately. But we would be physically together. Well, last March, that all came to a screeching halt. And there was quite a time that went by before mediations were even being held at all.
Oh yeah.
And lawyers and people who were looking at possible mediations, whether they were represented or not, were basically standing by the sidelines waiting to see how long the shutdown was going to last.
Yeah.
And when it became evident that this was going to go on for a while, and it also became evident that we had this thing that nobody, at least I hadn't, and perhaps you hadn't either, that no one had ever heard of, called Zoom, was out there. Little by little, mediators started to pick up the Zoom ball. And as we did that, and as lawyers and parties became more comfortable with that process, we're mediating by Zoom now. We're doing it remotely.
I mean, it's effectively the same, because you can even do the breakout sessions if you want, so that you can have your own private conversation with one party, and the other party is just sitting there waiting for you to come back.
Exactly. And a major advantage to Zoom is that it doesn't matter where the parties or the lawyers are located. They could be literally anywhere in the world.
Yeah.
I mediated a trust and probate dispute about a week or two ago. One of the parties was in Vietnam, and it was a long mediation. We got it resolved at the end of the day and into the wee hours of the morning. But again, one of the advantages is it didn't matter where the parties were located. And another advantage that I've found is that because people are by and large Zooming from their own homes, their home offices or somewhere within their own home, they are far more relaxed and far more comfortable, and therefore far more better suited to actually hear and become engaged in what's going on, as opposed to being fearful of the setting as if they were in somebody else's office that they weren't familiar with.
Or a courtroom. You know, it's very intimidating being in a courtroom.
Yeah.
So what types of, well, actually, let me ask you this.
Sure.
How long does mediation usually take in your experience?
Yeah, it really varies, Edward. The shortest, and again, it depends upon the type of dispute, the complexity of the issues, the number of parties that are involved that all have to agree to a resolution. I would say generally the shortest is perhaps a half a day with some preparatory work before that. An average maybe a full 8-hour day. This last one that I did went 15 hours. We started at 9 in the morning, finished about midnight.
Wow.
The longest one I've ever done started at 9 in the morning and finished at 6 the following morning. Literally.
You must have taken some breaks.
We did off and on, and that was back in the day when we were doing these in person, and there were several reasons why that happened.
But now that and if I'm the either the plaintiff or defendant, and I am hiring you,
yes,
I have to hire you not only for that time, but isn't there some preparatory time, because you got to understand the case?
Well, absolutely. Yeah. And I'm a firm believer that you have to hit the ground running on the day that you're getting together, whether it's remotely or in person. And the only way to do that is through a lot of preparatory work. Exactly. Talking with the lawyers, talking with the parties, getting information, making sure that they have exchanged all the information they need to exchange for both sides to know where the other side is coming from, making sure that you have all of the proper people there on the day of the event, the right decision makers that can sometimes involve insurance carriers as well as the parties themselves. So there's a lot of work that goes on ahead of time.
And I got to think there's going to be so much more confidence in the mediator when you realize, you know, this guy's really done his homework. He knows just about as much as I do about the case.
Absolutely. And it is totally helpful to the process where the parties have developed some element of trust in the mediator for the reason you just mentioned, as well as a trust in the sense of understanding that the mediator is there completely neutral, no stake in the outcome, because at some point in the process, I almost always in private session share my thoughts and observations with the decision makers as to risks I would ask them to at least consider when making settlement decisions.
Well, that's the thing. It's like, listen, Mr. Jones, if you hear we're trying to mediate this thing, and if we don't come to an agreement, this is how I see it as the mediator going to the next step, be it arbitration or whatever, and here's your risks. You might lose on this. So, what do they say? A good, I mean, I'm just kind of throwing this out here tongue in cheek, but they say, a good settlement is when both sides walk away unhappy. But that's not really.
Yeah, see, I don't buy into that.
I don't either.
My goal is for everyone to walk away happy. And when that doesn't always happen, but when it does, that's when I've had a really good, satisfying day.
How long have you? Now you told me how long it's taken for the mediation part. What has been like your longest and shortest period pre-mediation for you to do your assessment?
Good question. I would say the shortest, and I'll do this in number of hours rather than days. I usually assume around 4 or 5 hours of prep time.
Yeah.
Sometimes that's enough. Sometimes it isn't.
Do you get like a narrative from each attorney as sort of a summary?
Yes. We call them mediation briefs.
Okay.
And I always ask for mediation briefs to be provided to me and exchanged with the other side a week ahead of time for that very purpose.
Very smart.
Yeah.
Before we let you go, also, we need to know if our listeners wanted to contact you, because I know a bunch of mediators, and I got to say that if I were in a situation of being either the plaintiff or the defendant, I personally think that you're the most balanced one I've met.
Thank you.
So you have my endorsement from that end of it.
Thank you. Greatly appreciate it, Edward.
I was going to say, thank goodness I've never needed your services. But that being said, how do people get a hold of you if they unfortunately need your services?
Sure, you bet. My phone number is 415-492-4500. Okay. My email is phil@diamonddisputeresolution.com, and my website is diamonddisputeresolution.com. And Edward, do I have time for just 30 seconds more on one of the things that you asked me earlier?
You know what? We have to cut to one last break. There's no trivia question, but when we come back, you get to start off. All right?
Perfect. Thank you.
Okay. Stay with us, audience. We're going to come back with some closing comments on the best of investing. Don't touch that dial. Welcome back to the Best of Investing. Last time for today, I'm Edward Brown, your host, along with my special guest, Phil Diamond, Esquire, mediator and arbitrator. He's also an attorney. So we didn't have a trivia question, but Phil, I had to unfortunately cut you off before this last break. What did you want to share with us? You
asked me before about what has changed since COVID, Edward, and one of the other things I wanted to mention to you is that COVID has obviously resulted in a number of commercial tenants struggling with their leases because of the shutdown of their businesses, whether they're temporary or permanent. And so one area that is perfect for mediation is the resolution of commercial lease disputes. And the reason I mention that is that if a commercial property owner, a landlord, and the commercial tenant can actually get to what it is that is below what they need and why they need it, oftentimes those disputes can be resolved as well. And one example I give is, let's say you've got a commercial tenant that is struggling because of COVID, and the landlord who obviously wants to collect the rent, but the commercial tenant has 2 years left on the lease, but he'd like to retire. The commercial landlord, on the other hand, knows that he can develop the property into a higher and better use, and so his interest is in trying to get the tenant out of there. So what's the obvious solution? If they both know what it is they need, not just what they're asking for, it's an early lease buyout and everybody wins.
Yeah, and I've actually heard recently of a situation where there was a fairly large tenant and who had lots and lots of employees, and the problem was that the building was locked completely, not only just for the public, but these employees could not access their own space, and they needed to for various reasons. It wasn't, not all the stuff could be done by Zoom. And effectively the tenant basically said, "Hey, you can't charge us rent if you're not even going to let us access our own building." And that, I could see that definitely being a situation where, the landlord is saying, "Gee, I got to health-wise protect everyone from COVID, but I also want to collect my rent, but I can't preclude my tenant from accessing the building." And so I don't know. I don't remember how it resolved itself, but I could see that being a potential issue, let's call it.
Absolutely. And there are a lot of legal issues involved in that. As a real estate lawyer, I also get involved in those disputes on behalf of either the landlord or the tenant. But as I'm saying, they are perfect for resolution by mediation.
In fact, sometimes I could even see you acting as your own mediator. That's probably not allowed, though, I got to
Well,
think.
it's funny you say that. Right now, I'm in the middle of a negotiation where I'm representing one of the parties, but I'm doing it by presenting mediation principles to the other side, and basically, just as you did in your example, presenting them with both their argument and ours, doing a risk analysis on both sides, and then presenting our position. So we'll see where that goes.
Very, very smart. And the one thing you got to hope for is that you have a reasonable opposing, not only counsel, but that client, because sometimes you can't fix crazy.
Exactly.
And I'm sure you run into situations like that where it's like, you're not seeing the forest for the trees, as they say, right? That happens. Well, again, Phil Diamond, Esquire. I like that Esquire. Not only mediation, but arbiter and real estate broker, which really helps because the fact that you know real estate, and I got to think that a lot of mediation and arbitration issues revolve around real estate. It's good to have that experience. So again, thank you for joining us, and we're going to give our thoughts for the day here. All right. And there's sort of thoughts and then a little bit of puns too. So the thoughts part of it is success is not the key to happiness. Happiness is the key to success. If you love what you're doing, you will be successful, said Albert Schweitzer. Very nice. Here's now we're going to get into the kind of the puns here. Why don't they play poker in the jungle? Too many cheetahs. Ba-dum-bum. You like that one? Okay.
Rim shot.
Too many cheetahs. All right. Tune in next week to The Best of Investing. We're going to be giving away more free prizes for answering trivia questions. Thanks for listening. On behalf of our team, I'm Edward Brown, wishing you the best of investing. So long.